Yes, this is the ruling. Numerous rulings. I'm beginning to lose counts. This is the second for the day. In this application, the prosecution sought leave to amend their charge sheet. The application was motioned through citing of Section 214 of the Criminal Procedure Code. The application is in two folds. One, they seek to effect amendment seeking to invoke the correct date. In this, the learned prosecutor sought to amend instead of diverse dates from 12 May 2023 to 18th May 2023 to read from 11th May 2023 to 18th May 2023. The charges are to affect count 1, 3, and 4 of the parent charge sheet. The second limb of the intended amendment is to change the reading of the name of the ninth accused person from John Njenga to John Maina Njenga Kamunya. He asked that the application be granted. The application was opposed by the learned counsels for the accused. Mr. Ondieki indicated that Section 214 of the Criminal Procedure Code is to be invoked by the court and not the prosecution, as the case herein. Similarly, the counsel alluded that by granting the application would amount to visiting prejudice upon the accused persons with specific reference to the ninth accused. The counsel took issue with the fact that the ninth accused in the principal charge sheet is proposed to be the first accused in the proposed, hence discriminating against the ninth accused person. This point was reinforced by submissions by Ms. Tamburu. They maintain that the proposed charge sheet would greatly prejudice the accused person. Mr. Ondieki similarly indicated that the proposed amendment would greatly change the form of the particulars of the charge, hence prejudicial to the accused person. He called for the rejection of the application. Mr. Simon Buru submitted further that the prosecution has not informed the court the defect in the present charge sheet, either in form or substance. He asked that, noting that nothing has been demonstrated to the court to warrant the court to exercise its discretion in favor of the prosecution, he too called for the rejection of the application. Mr. Omwenga, the learned prosecutor, reiterated his application and rejoinder. This is the information. Let me begin by citing Section 214 of the CPC, with which the application is heavily premised. Section 214 provides as follows. Where at any stage of a trial before close of the case for the prosecution, it appears to the court that the charge sheet is defective, either in substance or form, the court may make such order for the alteration of the charge, either by way of amendment of the charge or by substitution or addition of a new charge, as the court thinks necessary to meet the circumstance of the case, provided that 1. Where the charge sheet is so altered, the court shall thereupon call upon the accused person to plead to the charge so altered. And 2. Where a charge is altered under this subsection, the accused may demand that the witnesses or any of them to be recalled and give their evidence afresh or be further cross-examined by the accused or his advocate. In the last mentioned event, the prosecution shall have the right to re-examine the witness on matters arising out of further cross-examination. The second limb does not apply in this case. This provision should be read in tandem with Section 134 of the Criminal Procedure Code, which provides that every charge or information shall contain and shall be sufficient if it contains a statement of the specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving reasonable information as to the nature of the offense charged. In this case, the points of suggested and intended amendments have been pointed out by the prosecution to be the names of one of the accused and the particulars of the dates of the alleged offense. What this court ought to guard in such instance is the net effect of granting the application, where it appears to cause prejudice to either of the party, then the court should outrightly deny such leave. The case herein is in its nursery stage. Indeed, it was coming up for pretrial direction. Not a single witness has been put to stand. This alone extinguishes any possibility of prejudicing the persons charged. It has been submitted by the defense that the principal charge is in conformity with Section 314 of the Criminal Procedure Code. Hence, there is no need to amend. The question that would arise is what prejudice would the intended amendment cause to the accused? To me, the proposed charge sheet would give proper particulars of the charge, which should aid all the parties, including the court, during trial. In the upshot, and in the absence of any potential prejudice to the accused by the intended amendment, I allow the application by the prosecution and consequently grant leave to the prosecution to amend the charge sheet. I reluctantly wish to comment on the fact alluded to by the defense of bringing the ninth accused to be the first accused. I do not wish to make reference to the proverbial oaths as put forth by the parties. The net of it is that the appearances of parties in a charge sheet has no connotation to the weight of the charge against the person charged. Let me end it at that. Those are the orders of this court.